very long time, and didn't have an audience. Not sure why. We're glad you're all here. We're glad we're all here. This is cause number 20-0197, State of Montana. State of Montana versus Richard Hinman. Time set for oral argument. Ms. Neal, you appear to be ready to go.
I am ready to go. Thank you. Good morning. May it please the court. My name is Christina Neal, and I represent the appellant, Mr. Richard Denver Hinman. I would like to reserve 10 minutes for rebuttal, please. Montana's Constitution protects all people, and it prohibits the deprivation of rights based solely on speculation and fear. When Mr. Hinman pled guilty to his offense in 1994, he would have been known he was obligated to register as a sex offender for 10 years. Registration meant he provided his name and address to law enforcement. If he failed to register or maintain his registration, the penalty was a misdemeanor of 90 days in jail and a $250 fine. This changed in 1995 when the Sex Offender Registration Act, or sometimes referred to as SORA, was amended to require him to register for life, and the penalty for failing to register became a felony. In 2003, this court decided State versus Mount and held that the application of this lifetime registration to individuals such as Mr. Hinman did not violate the ex post facto clause of the United States and the Montana Constitutions. When the court decided Mount in 2003, the obligations on an individual required an individual to register were expanded in that an individual had to provide their name, address, fingerprint, and a photo, and this information along with the type of victim, the specific offense, and conditions imposed by the sentencing court. This information could be disseminated via the internet. Twice a year, Mr. Hinman was sent a form verifying his address, and he returned the form via mail. In 2019, the date of Mr. Hinman's current offense, the scope of the state's intrusion into a registrant's life had vastly expanded. Mr. Hinman was now required to appear twice a year in person to update his registration. Mr. Hinman was required to register for life and could not even petition to come off the registration for 25 years. And the public was provided much more intimate details about Mr. Hinman's life.
So let me ask you about that part of it, counsel, the expanded conditions and requirements that have been added to the law since the court decided Mount in 2003, which was addressing the 2001 version of the statute. So the version that the court upheld in 2003 had lifetime registration, was a felony, had retroactivity in it. Is it your argument that the decision in Mount, given the conditions before the court of the statute then, was incorrect? Or is your position that since Mount was decided, it's the additional conditions that have been added since that render the statute unconstitutional?
Thank you, Justice Rice. While I may not agree with Mount, my position in this case is in relation to Mr. Hinman is that since Mount, the additional conditions and amendments that have been added to the statute make Mount no longer applicable or good law when looking at the statute as it stands today.
It was good at the time, but it's no longer good for the current statute.
That is correct, Justice Rice. The information that was collected for Mr. Hinman in 2019, or at his conviction in 2019, included his name, his social security number, his residence, his employment status or where he worked, if he was going to school, what schools he attended, his driver's license number, his car description, his license plate number, his DNA, his email accounts, and his social media accounts. If he changed residences, if he changed schools, or if he changed jobs, he was required to report in person to law enforcement and update those changes. The public was provided additional information of the address, his photograph, his date of birth, his offense, his vehicle information, and his email and social media information. Mount applied a test set forth by the Supreme Court of the United States called Smith versus Doe to determine whether it was ex post facto. Today I will address how applying Smith versus Doe's relevant factors with the statute Mr. Hinman was subjected to in 2019, Mount is no longer available or no longer good law. Smith applied what we have termed as an intent or effect test. First, the court looked at the intent of the statute. The intent of the statute in 2001 or in 2003 when this court decided Mount was protection of the public from sex offenders. That intent has not necessarily changed with the statute at this time. So then the next step is to look at the effect of the statute. And although the intent of the legislature has not changed, the effect of the multitude of the amendments from 2001 to 2017 have made the effect punitive.
Excuse me, Ms. Neal, just to follow up on Justice Rice's question and the point that you were just making, the essence of your position then seems to be, or the upshot of it is anyway, that the act is now more onerous and intrusive than even it was in 2001, 2003 when Mount was decided. So specifically, what aspects of it do you find to be significantly more onerous and intrusive or burdensome now than at an issue in Mount?
Thank you, Justice Sandifer. I would start with one of the first factors that the court looked at in Smith versus Doe and this court in in Mount looked at whether there was an affirmative restraint. And one of the criteria that was looked at was that Mr. Mount, once he appeared in person, registered, from then on he was sent a mail or card, he mailed it back and verified his registration. Mr. Hinman now, with the changes, must appear twice a year in person at a police station and verify those changes and be photographed yearly as verification as well. Additionally, the type of information that was acquired from a registrant at the time this court decided Mount versus the statute now is much, like you've indicated, much more onerous. The information that was required of Mr. Hinman that would not have been required of Mr. Mount was, for example, where he was employed, his information about his vehicle, his information about email, about social media. The other requirement is if he has any type of life changes. For example, he quits his job and he tries to get a new job. Within 3 days, he's got to report in person to a police station with those type of changes.
Counsel, can I ask you to clarify, is your objection to the post-enactment offenses, the ex post facto issue, that's clear, but what about the requirement to register after the sentence has been completed? Are you raising that objection at all?
Justice McKinnon, I think that is part of the analysis in the ex post facto analysis, because Mr. Hinman's sentence was completed in 2000. He had served a sentence and had completed his sentence in the year of 2000. So I think that's part of the ex post facto analysis, is you have an individual whose sentence has completely been served, and I think that's part of the analysis also in the rights restored argument that Mr. Hinman has raised as well.
All right, but if you had a defendant, I know that we don't have that here, and that may be the answer, but if you have a defendant and the sentence is a 30-year sentence, but they're required to register for life, and that's in effect at that time, is there any problem with that? In other words, requiring registration beyond completion of the sentence?
Justice McKinnon, I don't necessarily think that requiring registration beyond the completion of the sentence is the problem. It is when it's applied to somebody that's completed their sentence, and then you've added the amendments as well.
Thank you, that helps.
Thank you.
Let me just follow, so I'm just want to make sure that I'm understanding them, because, so the ex post facto is under Article 2, Section 31. But then, are you saying they kind of, they dovetail with Article 2, Section 28, which is the restoration of rights? Or are they independent arguments, I guess is?
Justice Shea, I think they dovetail. I think they can be independent arguments, but I think they can also dovetail. I think more that complements the restoration of rights would be your right to privacy and the additional requirements and dissemination and what he's providing to law enforcement that violate that right to privacy with regard to the restoration of rights. So I think they're independent. They can dovetail, but I do think it can be analyzed as two independent arguments.
So Justice Shea was much more articulate about what I was asking. Okay. So you are not raising the restoration of rights issue?
Justice McKinnon, no, I think we are raising that issue. I think that they can be addressed as two separate issues, but we have raised both of those issues.
So to be clear, after a defendant has completed the portion of their sentence and should be restored to rights, you're saying that registration requirement violates that right to be restored all of their civil rights?
Justice McKinnon, yes, the registration and I apologize if I misunderstood the question before. The registration requirement, as it is in the 2017 statute, violates that portion of the Constitution.
So just to get back to your affirmative restraint argument, you mentioned in Mount that he could update his registration annually by mail, whereas Mr. Hinman may not. But we also said he can move wherever he desires, and he can petition a court for an order relieving him of the registration requirement. Those two features of the law are still in place, correct?
Justice Baker, yes, those two features are still in place, but I would argue they're somewhat different. Even though Mr. Hinman can move wherever he would like, contrary to Mount, if he does move, within 3 days, he has to appear back at a police station to update his new address. And so I think that is what makes the affirmative restraint, is that in-person appearing within 3 days at the police station.
One of the arguments the state makes is that a level 2 offender can petition the court to lower the level designation. Has Mr. Hinman ever sought that relief?
Justice Baker, not that I'm aware of from the record of this case.
Ms. Neal, to follow up on some of these other questions as well, your ex post facto argument, I think, is the most interesting and problematic here for the statute and for the court to address. But so I don't want to bog down too much on this restoration, which I view as a secondary or ancillary argument. But to the extent that you've discussed that today, exactly what civil rights have not been restored to this individual if this statute is not found to be defective?
Justice Sandifer, I would argue that the right to privacy, and this court in Mount, when they were looking at that particular issue with regard to the rights restored, had found that the privacy violations were narrowly tailored by the information that Mr. Mount was providing to the law enforcement. I would argue that the information that Mr. Hinman had to provide in 2017 was significantly greater and much more private information. For example, his vehicle, the license plate number, where he works, where he was attending school, that's much more detailed. And so it is no longer narrowly tailored as this court had held in Mount.
So I have a question. The life changes as well. you're saying any life change, they have to show up in person within 3 days?
Justice Gustafson, they would need to appear in person with changes to their residence, to their place of business, or to where they were attending school.
Okay, so job changes?
Yes,
Right.
Justice Gustafson. Further, this court in Mount, looking at whether it was an affirmative restraint, emphasized that all registrants can petition in 10 years to get off the registration. And that goes somewhat back to Justice Baker's question. At the time of Mount, all individuals could petition to come off at 10 years. That's no longer the case. For somebody that's such as Mr. Hinman, that is a level 2 offender, that is 25 years, or somebody that is a level 3 offender, there's not that possibility to petition to come off, or somebody that their offense is a sexual intercourse without consent involving somebody under 12 or an incest of somebody under 12. And I would also point out with regard to the affirmative restraint or the affirmative restraint prong that subsequent to Smith versus Doe, the case this court relied on in Mount, the Alaska Supreme Court went back and looked under their Alaska state constitution and held that it was an ex post facto violation, even using the same factors as the Smith case. And what the Alaska court found in finding that the affirmative restraint prong was that the shaming involved in the public information provided and the no ability to petition was an affirmative restraint. The second prong that this court looked at and that was looked at within Smith versus Doe that I think is relevant is the historical treatment of individuals.
So Ms. Neal, excuse me, if we were to, could you walk us through in terms of the Montana Constitution how the enhanced is it the enhanced privacy interest, the right to privacy that we would look at, or?
And Justice McKinnon, I would argue that it's the enhanced right to privacy and Article 2, Section 10, that right to privacy clause that's separate from the United States Constitution coupled with the ex post facto clause would give this court the ability to make a ruling based on the Montana Constitution.
I don't believe Mount addressed the Montana Constitution in that fashion, did it?
And Justice McKinnon, Mount did not address the Montana Constitution in that fashion. Mount did find its ruling is based under both the United States and the Montana Constitution, but it did not make a finding in that regards.
Ms. Neal, I'm having a hard time tracking this privacy infringement argument because, first of all, our case law, I think as it has developed over the years, doesn't indicate that this court has viewed the enhanced Montana right to privacy as some sort of empty vessel that we can say on an ad hoc basis that, well, there's more privacy here under the Montana Constitution because we say so. As I see the case law in that regard is that we found a greater right to privacy under the Montana Constitution in regard to special concerns that the Constitutional Convention had in that regard. And for example, in the criminal search and seizure context, we have said, well, we're not going to recognize as many exceptions to the warrant requirement. But what basis in Montana law can we say that there's a greater Montana right to privacy here that should come to bear in this case? I don't see where you're pulling that from other than saying it.
And Justice Sandefur, I think in relation to Justice McKinnon's question, this court did look at and address somewhat the privacy. It didn't cite to Article 2, Section 10, but to the privacy concerns when this court looked at Mount and had found that the privacy concerns of an issue at Mount were narrowly tailored to fit the purpose of the statute, that being protection of the public. And my argument is that that has gone beyond now with the additional information that Mr. Hinman is now required to provide law enforcement.
Excuse me, that information, though, as you indicated, is vehicle registration information, employment information, where you're employed or when you're changing employment. Are there other aspects that you think are particularly problematic or invasive from a privacy standpoint?
From a privacy standpoint, to me, those are particularly invasive, as well as, I mean, his email address is now turned over to law enforcement. If he changes, somewhat related to employment, if he changes schools, his photograph, his identifying features to his body, I would argue that those are all those all relate to a privacy concerns for Mr. Hinman.
And that includes social media accounts.
Chief Justice McGrath, yes, that would include any type of social media accounts.
I mean, essentially, it's a way to monitor. I mean, that is the purpose of the statute, is to monitor where somebody is. And I think the connection to the right to privacy there is very clear.
And Justice McKinnon, I think it has definitely expanded from gathering information where an individual might be to almost more of a surveillance type with that ability. Yes, Your Honor. Further in looking at the historical treatment, this court in Mount, as this court is aware, allowed for the internet dissemination. I would argue, though, the internet has, from what it was in 2001 or 2003, has greatly expanded. It's now at our fingertips all the time, whereas in 2001 it would have been more of a search engine. The New Hampshire Supreme Court analyzed traditional shaming cases when looking at that historical treatment prong of people that were brought into the town square and ostracized. And the court explained the internet is now our town square, and I think that's a difference from what was occurring at the time in 2001 when Mount would have been in place. The third factor that this court that I think is relevant is the traditional aims of punishment. One of the factor that this court really relied on in State versus Mount was the ability to petition to come off the registry in 10 years for all offenders. As indicated, now somebody like Mr. Hinman cannot even petition for 25 years. And the other factor that this court found important in Mount with regard to the traditional aim of punishment was the ability to just verify your address by mailing in a card. Now, Mr. Hinman has to report twice a year and be photographed every year. The fourth prong that this court, I think, is relevant with regard to the Smith versus Doe test would be the non-punitive purpose. The purpose of the statute, even the explicit purpose, is the protection of society. But over the last 20 to 25 years, as social scientists have looked at the evidence, it's not as effective. Registration statutes are not as effective as I think they were thought or hoped they would be at the time of Mount, and definitely at the time the United States Supreme Court decided Smith versus Doe. And the fifth prong, I think, that is the most relevant from what was considered by this court in Mount is the excessiveness in relation to the stated purpose. The current SORA is excessive when compared with the purpose and with the past versions of the act considered by this court in Mount. I think it's the aggregate effect of all of the additional amendments, the reporting in person, the more private information that is being gathered, that with consideration that it is not as effective as a means of protecting the public as once was considered at the time that Mount was considered in Doe, along with when you're changing your job, your school, your residence, you must report in person every 3 days.
Ms. Neal, though, when we're talking about the efficacy of the regulatory aspects of this, that seems to me that we're now in the wheelhouse of where the legislature's constitutional authority is to regulate in the public welfare and safety. And it seems like you're asking us, at least in regard to that aspect of your argument, to substitute our public policy judgment for the legislature's. And that's not where we're supposed to be in general anyway. What do you say about that?
And Justice Sandifer, what we're asking you is to find that the statute as applied to Mr. Hinman violated the ex post facto clause of the Montana Constitution. If that's this court's finding, then it's the legislature that needs to remedy that.
But if that's what the primary focus of your argument is, then doesn't that have to be focused on the penal nature of this statute and its effects, as opposed to the regulatory efficacy of it for purposes that the legislature is trying to advance?
And Justice Sandifer, I'll see if I'm answering your question correctly. I think the punitive, it's a civil statute, but the punitive effect of the statute comes in through the affirmative restraints and through those factors, such as having to appear at a police station twice a year to update. That becomes a punitive.
I guess that's what I'm trying to get at. I didn't ask a very clear question. Is that it seems to me that to the extent that you're making arguments about the lack of or reduced efficacy, or however you want to characterize that, of this as a regulatory means to track these people in furtherance of public safety, etc., that to me doesn't really bolster the argument that this is a statute that's more penal in nature than regulatory for purposes of ex post facto. So what's the best argument that you can make that this statute is more penal in nature, as recognized by the Alaska Supreme Court and the dissenting opinions in the Smith case, as opposed to being a regulatory, more predominantly regulatory statute?
And Justice Sandifer, the argument I would make is that when you have somebody that is being so tightly controlled that they're reporting every time that they have a change in a job, every time they change residence to a police station, it's akin to being on probation or parole, which is a punitive effect then as well. The 2017 statute in which Mr. Hinman was charged and convicted was unconstitutional because it violated his ex post facto clause when it applied to Mr. Hinman. Mr. Hinman's conviction must be vacated. The statute in 2017 may be constitutional, but just not applied to Mr. Hinman and others like him whose criminal conduct triggering the registration conduct predated the passage of the most expansive legislation, which occurred in 2007. Therefore, convictions such as Mr. Hinman's, whose underlying conviction was in 1994 and predate those 2007 amendments, are unconstitutional. And with that, I would reserve my remaining time.
May it please the court, my name is Mardell Ployhar. I'm an Assistant Attorney General representing the state of Montana. The district court correctly denied Mr. Hinman's motion to dismiss on ex post facto grounds because Montana's Sexual Offender Registration Act is a non-punitive regulatory scheme that is properly applied retroactively. The current version of the Sexual Offender Registration Act is similar to the Alaska Act that the United States Supreme Court examined in Smith v. Doe, and which the United States Supreme Court determined was a non-punitive regulatory act designed to protect the public. This court already concluded in State v. Mount that the 2001 version of the Sexual Offender Registration Act was not punitive and could be applied retroactively. This court concluded that protection from the recidivism of sexual offenders was the act's paramount purpose. The same conclusion applies to the current version of the act, which is similarly a non-punitive regulatory act designed to protect vulnerable members of the public from the recidivism of sexual offenders. Well, that is the state's primary argument. The state also believes that if this court concludes that some portions of the current version of the act are punitive, this court should still uphold Mount and continue to conclude that the 2001 version of the act was not punitive, and most of the changes that have been made to the Registration Act since the 2001 version, most of those changes were made in 2007. The state believes that at least at a minimum, the 2005 version of the act is not punitive and should continue to be applied retroactively. Additionally, the 2007 act that made significant changes to the Registration Act, that was known as Jessica's Law, that act contained a severability clause at the end of it, and so if this court concludes that some portions, some changes that were made in 2007 have made the act punitive, the state believes that this court could strike some portions for purposes of retroactivity.
Ms. Ployhar, in that regard, and I realize that that's not your primary argument, because your primary argument is that this is fine as is. So I'm not asking you to argue against yourself, but in the event that we did go down that road, which aspects of the act as it sits now do you think are the most suspect from a penal versus regulatory standpoint?
Well,
He's not asking you to argue.
are you against my case?
Well, you brought it up, so
Well,
it's a
yes.
fallback position,
Yes,
so
I understand.
you
Yep.
must have something in mind.
Well, and yes, I of course want to make it absolutely clear, the state does not believe that any portions of the current act are punitive, but we also, of course, are aware that the court could disagree with that in portion, and one example might be the state certainly does not believe that the fact that Mr. Hinman has to appear 2 times a year makes the act punitive. But I also recognize that in Smith versus Doe, the one piece of Montana's current act is very similar to the Alaska Act that the United States Supreme Court held in Smith versus Doe. But they did note in there that the registrant in Smith versus Doe didn't have to appear in person. I think that is a minimal obligation to have to appear 2 times a year. The state does not believe that makes it punitive. But if this court disagreed and concluded that having to appear 2 times a year makes this act punitive, this court could determine that that portion was added in 2007, like many of these other requirements. This court could determine that that makes it punitive, and therefore that piece should be severed for purposes of retroactive applicability. It would still apply to people who committed their offense after the act went into effect, which was on May 11, 2007, but it won't apply retroactively.
It seems like the 3 days of personal appearance for, other changes is even more onerous than the twice a year.
Your Honor, I understand that, and that I believe that also went into the act in 2007. That is another example of something that this court could strike for purposes of retroactive applicability. But overall, this state, of course, I'd like to emphasize the state's primary argument, which is that this act is not punitive. It's very similar to the Alaska Act that was upheld by the United States Supreme Court in Smith versus Doe. The United States Supreme Court explained that states may impose restrictions on citizens retroactively if the intent and effects of the law are not punitive. It emphasized the ability of governments to create civil regulation.
Well, Ms. Ployhar, now that we're back onto your primary.
Yes, thank you.
What do you say about Ms. Neal's position, among others, that this lack of ability that was taken away to petition for relief from this after 10 years renders this more punitive? What's the state's response to that?
That change is one factor, of course, that this court needs to consider in all of the Kennedy versus Mendoza-Martinez factors, but that change does not render the current act punitive for a number of reasons. First of all, as I believe Justice Baker brought up, Mr. Hinman is a level 2 offender. If he had completed sexual offender treatment, we have no evidence whether or not he has, but if he has completed sexual offender treatment, he has the ability to petition to try to be reclassified as a level 1 offender. If he's a level 1 offender, if he had successfully done that, he could try to petition after 10 years to try to petition for removal. That is one of the indications that the focus of this act is on protection of the public. If the focus of the act were more towards retribution, there would be no reason to have allowed somebody who completed sexual offender treatment
So,
to
Ms.
try to petition.
Puhar, I know that the defense, in their briefing at least, put forth some sort of data that suggested that registration hasn't shown to be effective in enforcing the policy or what the aim of the statute is. Do you have any evidence otherwise to share with us, or what's your response to that?
It is, the one study that's been relied on, I did look at. It's very difficult to draw any conclusions from it. I think it is impossible to know what criminal offenses are prevented by registration.
So you're not aware of any studies, though, that showed like that it does. I mean, we have the one that says it doesn't work to do this, and are there contrary studies out there that you know of that say registration improves to reduce rates of recidivism and actually accomplishes the protection of society?
I'm not aware of any studies that have concluded that, Your Honor. Even the main study that is cited, it has different results for the I believe it indicated that the registration actually helped reduce recidivism, but not the dissemination portion. But then it was different with people who had not committed offenses versus people who had. It really was not drawing a clear conclusion. But I acknowledge that we don't have.
Okay, it was drawing some conclusion. The registration, which has been around for a long, long time, and but now, or at least the defense was telling us, all these added things that they're disseminating to the public are really a breach of one's privacy. And then you're saying at least the study that's out there shows that that hasn't helped. All this additional information disseminated to the public hasn't helped reduce recidivism or protect society?
The study hasn't, they have not found evidence of it. But certainly, I think two things. One, it is very difficult to ever have evidence to show what crimes may have been prevented, and it's difficult with sexual offenses because they are greatly underreported. So any of these studies out there that have looked at sexual offense recidivism are looking at the number of times that somebody who commits an offense, the number of times that they are convicted again of a new sexual offense. And it's well established that many of these people are committing many sexual offenses that are never that they are never convicted of. Also, it's significant to look at what the motivation was behind these acts. Many of these acts are referred to as Megan's Law because of the death of a 7-year-old girl in New Jersey named Megan Conca. She was playing in her yard when she was lured across the street by the neighbor who was a convicted sexual offender, and she was sexually assaulted and killed. And her parents later felt like if they had known that their neighbor was a convicted child sexual offender, they wouldn't have allowed her to play in the yard unsupervised. if that had been some information they would have had, they could have prevented that offense. And when that occurs, it's impossible to capture, in statistics that has occurred, that, people have been aware of offense, aware of a sexual offender, and been able to protect their child and prevent that from occurring. I also, it addressed one of my prayer points, and I kind of forgot which one, but I also want to note that one thing that makes Montana's act very different than many of these other state registration acts. Actually, there's two things that make Montana's very different, but one thing is that Montana's Registration Act contains an individualized assessment of risk, and people are placed in tier levels based on an individualized assessment that is done based on a psychosexual evaluation done by a trained evaluator. That is not occurring in most of these other states. So some of the concerns that other state courts had when they looked at their Registration Act was that there was no individualized assessment of somebody's risk, and then they were being given requirements about how long they had to register and that they could never petition for removal without that individualized assessment of risk. That was something most courts found to be problematic, but Montana does have that individualized assessment. People are placed into tier levels based on
That's an assessment of, future prediction. What about the offender who has been assessed and predicted to be a high risk, but down the road actually has been rehabilitated? There's no mechanism, as I see it, to address that rehabilitation aspect.
It is true that if somebody is found to be a Tier 3 offender, they are placed onto the sexual offender registry for life. It's a very small percentage of the offenders who are found to be Tier 3 offenders. And if they are found to be this high risk to reoffend, I think it is reasonable for the legislature to believe that they need to register for life, because there's no indication that, there's no way to know that anybody is ever fully rehabilitated as a sexual offender. It is a reasonable decision from the legislature to take that step and prevent those individuals from being able to petition for removal. But they're a very small portion of the sexual offender registry. And most significantly for purposes of this case, that is not Mr. Hinman. I don't think Mr. Hinman has standing to challenge portions of the act that don't even apply to him. He is a level 2 offender. He is able to petition for removal from the registry. He'll be able to petition in 2025. And of course, if he had completed sexual offender treatment, he could have petitioned to try to be reclassified as a level 1 offender.
That's a valid point, because this is a as-applied challenge by Mr. Hinman, but I guess where I'm still confused about this a little bit is how has Mr. Hinman's ability to petition for relief from this changed under the 2007 version of the act that applies as opposed to what it was at the time when he was sentenced?
Yes, Your Honor. So in up to 2005, he would have, as a level 2 offender, he would have been able to petition for removal after 10 years on the registry.
So, but at the time he was sentenced,
Yes.
what was it?
At that time, sexual offenders had to register for 10 years. So it was not the lifetime registration.
And then and the violation for that was it a misdemeanor?
That was a
or
misdemeanor, yes.
Okay, so that was a misdemeanor, okay. And I'm sorry, I didn't mean to interrupt, Judge.
No problem, yes.
So it was 10 years,
10 years of registration, and then it
it just ended, he didn't have to petition?
Yes.
And then now it's what?
Now it is, so first of all, just as far as steps, at the time that Mount was decided, it was lifetime registration, but offenders could petition for removal after 10 years. Now that is still the case for level 1 offenders, but for a level 2 offender like Mr. Hinman, he can petition for removal after 25 years.
Thank you.
So counsel, so what is the effect, because you were talking about then he would be eligible to petition in 2025, but in order to, one of the considerations for the petition under 5063A is that he has remained a law-abiding citizen. So what is the effect of, there's a felony conviction now for failing to register? What is the effect of that then?
I don't believe that that phrase is defined anywhere in the
I-
statute,
no,
so
I
I
could
think
tell
it
either.
really comes down to the discretion of a district court judge at that point to determine whether somebody has committed offenses that are significant enough to create concern about the ability to remove them from the registry.
In other words, there must be some sort of nexus between the offense that was committed and,
Well, I think a district court could also look at maybe the time that the offense was committed, if somebody shortly after being released from prison committed a minor offense, or if they're committing maybe regular offenses and it's kind of ongoing at the time they petition for removal. That term is not defined under the statute, and I think it would come down to the discretion of the district court at that point.
okay, thank you.
But that's a good point too, though, is that if it can be any offense, not just offense that might be indicative of a greater risk of recidivism for a sexual offense, but just any offense can trigger this or indicate him as not a law-abiding citizen, then doesn't that make this more akin to a penal corrective probation situation that extends on?
Well, when that statute is read as a whole, there is the law-abiding portion, and the other portion of that statute that a judge looks at when deciding whether to remove somebody from the registry is whether they can safely be removed without being a danger to the community. I think when that is read as a whole, I think the law-abiding portion should also kind of take in that purpose, that is the purpose to determine whether somebody is a danger to the community. Maybe if they committed one DUI, maybe that, like I said, I think it comes down to the discretion of the district court, although this court could probably interpret that statute and provide some guidance on that statute too, to interpret it if the court believes that a broad interpretation makes it unconstitutional. I believe this court could provide a narrower interpretation of it so that it had to be a violation of something that could be related to a sexual offense. One other significant factor about Montana's law that makes it very different than some of these other state courts that I want to make sure I point out, because I think that in the briefing from opposing counsel, there's a list of some other courts that have found that their registration acts were punitive. And so, of course, as I mentioned, one thing that other courts were concerned about was the lack of an individualized determination of guilt. But the other thing is that most of these states have very broad geographic restrictions that have been placed on where offenders can live or work, and in some cases even loiter. And in many of these cases, these restrictions are applying to all of the sexual offenders on the registry. So one of these courts noted that in large cities, some of these offenders, these registrants, have to tailor their daily lives around these requirements because they may not be able to stand at a bus stop because they can't loiter there. That does not occur in Montana, so that makes Montana's act very different. Montana does have a narrow geographic restriction. It is not contained in the Registration Act. It is at 45-5-513. It applies only to Tier 3 offenders who have a victim under the age of 12, and it also only applies to living and working within 300 feet of a school. Most importantly, it does not apply to Mr. Hinman. So I don't believe he can challenge that provision. It does not apply to him, and it is a significant difference when looking at all these factors that makes Montana's act narrower and different than some of these other acts in other states.
Ms. Plehart, what's the state's response to the argument that's been made here today, and which was a central consideration among others with the U.S. Supreme Court dissenters in Smith, that this, from a punitive effect standpoint, is the equivalent of modern shaming, and that's inherently punitive in nature. Why does the state view that as not a significant consideration here?
Well, if it was shaming, then that would be an important consideration, but the state agrees with, sorry.
No, I'm sorry, I interrupted you. I'm just going to make sure, move off the shaming, I guess the better focus of it was on the stigma that's attached to it.
Yes, well, the state agrees with the analysis from the majority of the United States Supreme Court, which was the same analysis that this court already adopted in Mount. This court has agreed with the analysis from the United States Supreme Court, the majority of the United States Supreme Court in Smith, and has explained that a registration act is not shaming. It's different than shaming, because the purpose of shaming, people in these small communities historically probably knew somebody had committed an offense, but they still put them in the town square for purposes of that direct face-to-face confrontation to create that punishment. It wasn't about notifying people. It was about using that as punishment. And that is not what the Registration Act is doing. And the United States Supreme Court and this court both noted that certainly the United States Supreme Court and Smith noted that the dissemination of accurate information is not punishment. That's not the law. So certainly just disseminating information does not make it punishment. The objective of the Registration Act is not to punish, it is to provide information to Montana citizens to help them protect themselves and children.
I think that's a valid point, but I think the other side of that, though, is that the focus is on the effect of this, and that despite the fact that that's the legislative purpose and public safety purpose of it, it nonetheless has that very significant negative effect on these people that then continues on long past the time that they've discharged their sentence. And in this case, as it relates to Mr. Hinman, long past the time that he was supposed to be subjected to that at the time he was sentenced. So how does that, is that not a very significant punitive aspect of this?
It is, the consequences are something that can be considered, but they do not make it punitive. I think it's significant that in Kansas versus Hendricks, the United States Supreme Court concluded that sexual offenders who were sexually violent, who they concluded were sexually violent, sexual predators who were dangerous, could be civilly committed they had to be recommitted every year, but they could be recommitted for the remainder of their life. And because the purpose was protection of the public rather than punishment of those offenders, the United States Supreme Court determined that that was not punitive.
But that gets back to this business that Ms. Nia was talking about, is that when you're looking at strict scrutiny, obviously the state has a compelling public interest, compelling government interest in preserving public safety and et cetera. There's no question about that. The question, though, if you're in that analysis, ultimately in a case like this is whether or not this is narrowly tailored to further that purpose. And I think that there's some problems there. Do you disagree with that?
Well, I'd like to first of all point out that the United States Supreme Court has made clear, and this court has also adopted the United States Supreme Court test, that the test for ex post facto purpose, the test for the excessiveness prong under the ex post facto test is not a strict scrutiny test like that. The test is whether the legislature, they specifically stated, the test is not whether a court thinks that they could create a narrower law or create a better test. The test is whether the means chosen by the legislature were reasonable to pursue a legitimate government objective. So the test is simply whether it was reasonable. The state's position is that the actions taken by the legislature were reasonable. It's significant that this law does not prohibit any conduct from Mr. Hinman. He can live where he would like to live. He can travel where he would like to travel. It simply requires him to appear 2 times a year, unless he moves and needs to update his information, but it requires him to appear 2 times per year and provide information. Some of that information, not all of it, but some of that information is then disseminated on the internet.
What's the basis of that? And your argument was, it seems to be primarily focusing on the compelling interest here in public safety, which nobody disputes. But to the extent even that you're saying, well, the legal threshold here is just, it has to be reasonably related to it, what data or basis, other than saying that cursorily, does the state point to say that there's a reasonable relationship between the purpose of this and what its restrictions are?
Well, the courts have never said that there has to be specific data to
No, they
show it, and so I don't
to
have.
prove it, but you're still standing here saying it, so on what basis are you saying that?
Well, I think what the court needs to look at is whether it's a reasonable decision from the legislature. The legislature doesn't necessarily have to have data that makes it decide that this will work, but they can look at.
It can't act arbitrarily either.
And I don't believe it's acting arbitrarily, Your Honor, when it looks at an example like the Megan Conca case and looks at if her parents had known that the person living across the street from them was a convicted sexual offender, they would not have allowed her to play in the yard unsupervised.
That's a registration of name and address, right? But, it's good, the argument now is it's gone beyond that. So, like, having his email address, how is that? Megan, I realize that case is not before us right now.
Right.
But,
Yep, I understand.
just having his email address wouldn't help know where he lives or how to protect yourself from that. Or if he's driving his dad's car that day to go down and register, because it says kind of whatever car you're using, right? So, on a daily basis,
Your Honor.
those
Yes.
things might change, and I don't see how that protects.
I understand, Your Honor. I don't know exactly with each of those what exactly the thought of the legislature was.
Okay.
But I would assume with the car, for instance, that when there is a suspicious person who's been reported, who's maybe, pulled over and asked a kid if they want to get in the car, and that later law enforcement can know, oh, look, this person here was a convicted sexual offender. Even with the Megan case, they didn't. What they knew at first is they didn't know where she was, but they knew that the person across the street was a convicted sexual offender. That's how they ended up finding that that's the person that had killed her. So I would imagine that it would be a very similar situation with the email addresses and screen names. I think it's significant that they are not asking for like a password so that they can be looking into people's email addresses. Simply. And it's not even information that's disseminated, that email address. It's simply information that law enforcement has so that if they find that somebody with this email address is communicating with a young child and trying to lure them to meet up, they can know that that is the person. One other state, actually Indiana, I noticed when reading the case from their Supreme Court, they allowed that people who are on the registration had to allow searches of their computers. Well, that would be a very different situation. In Montana, it is simply allowing or requiring the registrant to provide an email address and screen name.
Counsel, you had said earlier the two things that made Montana's act different, and one of the things you said was the individualized assessment of risk. What was I don't think we ever got to the second.
It was the geographic restrictions, that Montana has very limited geographic restrictions, and those do not apply to Mr. Hinman.
Counsel, don't you think it's problematic to start down that path of evaluating each component of the Registration Act and assessing whether it's penalty or regulatory?
Well, I think it is necessary to look at the act overall, for sure. But if there is a portion that makes it punishment, or if there's one or two provisions that make it punishment, this court could choose to sever those that's specifically contained in the 2007 Act. I think this court could do that for other acts. If the 2001 version, if this court chooses to uphold Mount and conclude that at least the 2001 version of the Registration Act is not punitive, then that act should still continue to apply to offenders retroactively, even if this court concluded that the current version of the act could not. And I believe that the 2005 version, this court actually in State versus Hamilton also addressed the 2005 version and concluded that it applied retroactively. So at a minimum, the state believes that the 2005 version of the act should apply retroactively. We certainly believe that the current version also is not punitive and should continue to apply to Mr. Hinman retroactively, and I believe I'm out of time, so the state asks this court to affirm Mr. Hinman's conviction for failure to register. Thank you.
Thank you, Ms. Moyar. Ms. Neal? He's punching your number in here.
Thank you. Just in a brief rebuttal, one of the things that the state discussed is that with regard to the social data, and I'm just paraphrasing, that it's impossible to know the effects of the registration from the time of mount until now. I think that that goes then to showing that those amendments from the time of mount until now were not necessary and that they were excessive and they exceeded the purposes of the statute. If we don't see the social data supporting that the registration is effective, then they're adding amendments that impose additional burdens onto somebody such as Mr. Hinman become excessive compared to the purpose of the statute.
But Ms. Neal, that kind of runs into the state's argument, which perhaps you could address, about what the standard is. What's the test? I mean, we don't usually second guess the legislature's wisdom, and her argument, as we said in Mount, the excessiveness inquiry for ex post facto is not an exercise in determining whether the legislature has made the best choice possible. So the fact that the social data says one thing or another is really for the legislature to decide, isn't it?
And Justice Baker, I think the test under the prong, is whether the requirements imposed on the registrant in determining whether something is imputative, are the requirements excessive in regards to the purpose of the statute. And I think that from the 2001 statute until the 2017, those additional requirements are now excessive.
Counsel, when we look at this as, and it appears to me that this is exclusively an as-applied challenge, correct?
As to Mr. Hinman, I mean, I think the court can look at it broader, but as to Hinman, it has been an as-applied challenge.
So would one of the, to me at least, seems that one of the critical aspects of the as-applied challenge is that Mr. Hinman had fully discharged his sentence. Because is there anything in the Registration Act that could not be imposed as a condition of probation?
Justice Shea, and I'm just trying to think off the top of my head, I don't necessarily think that there is anything in the Registration Act that could not have been imposed as a condition of probation. I mean, your probation officer would know where you're living, would know your email address. Those would be similar to being on probation. Yes, Justice Shea.
Ms. Neal, it isn't an as-applied challenge because what's at issue here is the retroactivity of a statute, and the question is whether it's penal or regulatory. But if it's penal and you apply it retroactively, it applies across the board as it's unconstitutional across the board. Isn't that right? I mean, it's not an as-applied challenge.
Justice McKinnon, I think that's correct, and so I think I may have misspoken when I was trying to think through Justice Shea's question, yes.
I mean, the issue here is the retroactivity of a statute, and the question is whether that statute is penal in nature or regulatory.
Justice McKinnon, yes, I agree with you.
Following up on that question, your brief request in terms of relief that we overrule Mount and its progeny and hold that the retroactive application of the act is unconstitutional. That's a broad statement. Retroactivity cases are tricky, but is that an accurate statement of the relief that you are seeking here? All retroactive application of the act should be struck down. The state argued that, well, there's some, some parts of this that could be cut out and some retroactivity preserved, but what's your position on that?
Thank you, Justice Rice. And in my interpretation of the statute, similar to the state, would go back to the 2007 statute. And I think that's how we started this oral argument, and that the amount is just no longer is applicable to the way that the 2017 statute with the amendments. If you go back to, so I think that going back to the 2007 statute is when really the vast majority of the amendments that are so invasive and so punitive came into effect, would be in 2007.
I guess I want to just clarify, Justice McKinnon was saying it's not as applied, but I thought part of your argument was that given that he had already discharged his sentence, and it was something completely new that he didn't know about, that somehow that impacted it as applied. Is that correct or not?
And Justice Gustafson, I think it would, as to an individual that has completely discharged your sentence, similar to Mr. Hinman, whose conviction was in 1994, looking at the 2017 amendments and whether they are ex post facto. I think that was what I was referring to.
I'm sorry, Ms. Neal, I'm not trying to badger you, but I'm confused on what your position is on this. Let's focus on the ex post facto challenge. Is this a facial challenge, or is it an applied challenge?
Justice Sandifer, it would need to be, since we have challenged the retroactivity of this and the ex post and have argued that this statute in 2017 violates individuals such as Mr. Hinman, who have whose convictions were prior to the 2007 and the additional amendments. So it would be applicable to anybody similar to Mr. Hinman, whose convictions were prior to the 2007 amendments.
So, and completed, discharged prior to the 2017, or does that matter?
Prior to the 2007, and I don't think it necessarily hinges on whether the sentence has been completed. In Mr. Hinman's case, it had been completed.
So to kind of suss this out as much as, and we've got you kind of bouncing back and forth like a ping pong ball here, but would it be accurate to say then, maybe, because they don't necessarily have to be mutually exclusive, but the Article 2, Section 28 aspect of it, which exclusively applies to the restoration of rights, that would be as applied specific to Mr. Hinman, and recognizing that, as we discussed earlier, that the Article 2, Section 28 has some implication in the ex post facto, but the ex post facto, as Justice McKinnon would be saying, is dependent upon it being determined having a punitive effect. That would be the facial aspect of the challenge.
Justice Shea, that summed it up much better than I had been with my questions to Justice Sandifer, so
well,
thank
I kind
you.
of started the whole problem.
So if this court were to go back, and we would argue that the 2017 statute may be constitutional, but just not applied to somebody such as Mr. Hinman and others like him, whose criminal conduct triggering the registration predated the passage of the most expansive legislation, which would have been in 2007. So in conclusion, I think Mr. Hinman has committed no criminal offenses other than failure to register since his original conviction in 1994. 28 years ago, at the time of Mr. Hinman's original offense, Montana's Sexual Offender Registration Act was a relatively simple system dedicated to information gathering and tracking. However, Montana's SORA has progressed over the last decades into a far-reaching structure for regulating the conduct and lifestyle of registered offenders after their punishment is completed and for the rest of their lives. A thorough assessment of the Smith factors demonstrates that Montana's SORA, applicable at the time of Mr. Hinman's failure to register conviction, was punitive in its effect and is therefore unconstitutionally retroactive. Thank you.
Thank you, Ms. Neal. That concludes the argument